Well, good morning, good evening to everybody. We are connected from different parts of the world and we are in different time zones. I am Antonio Maria Baggio, Director of the Center for Research in Politics and Human Rights. I will say just a few words of welcome on behalf of the Center for the speakers and for all researchers and students connected. Our center is a center for advanced study that implements, promotes, and supports research and higher education in political, legal, and social sciences. Our main interest is human relations studied through the plurality of cultures and disciplines with an opening towards the complexity of contemporary reality. The center was academically established by the Sophia University Institute and promoted in collaboration with the international network of jurists and law practitioners, Communion and Law, and with the Tony Weber Foundation. I want to thank in particular for the help given to the creation of the center to Professor Adriana Cossetto, that is here with us. I am also speaking on behalf of her, and Dr. Maria Voce Hemmaus. The center promotes international cooperation in scientific research, favoring intercultural projects and the increasing inclusion of young people in research and high professional qualification. We will open space for dialogue and offer consultancy for the construction of new academic training courses. The new cycle of seminars that begins this evening is therefore a wonderful expression of our mission, and I am particularly grateful to the academic institution that together with us promote it. The Institute of Religion, Law and Lawyers Work, Fordham University School of Law in New York, and the Observatorio de Derechos Humanos de la Universidad de Valladolid, España. Well, I've talked enough. I leave the floor to the speakers, wishing them good work. Thanks.
Thank you very much, Professor Baggio, for your support in this initiative. The intention of the organizers of these seminars is to be able to dip into the main human rights challenges of the present time in an historical perspective, trying to identify the main challenges we face as members of the human family. 4 seminars are planned during this academic year to be announced, and we hope to continue during the next courses. I would like to warmly thank you 3 speakers of today for their availability and welcome all participants following this first seminar. I will introduce them, and after their presentations, there will be a discussion with the Zoom participants. You can make questions writing in the chat, raise your hands, and we'll give you the floor. The presentations are in English, but if you prefer, make questions in Italian. All speakers speak Italian, so there is no problem. Okay, the first speaker is Dr. Marilena Montanari, is PhD in International Law at the Pontifical Lateran University. She's working at the Permanent Mission of Holy See, and she's lecturer at the Sophia University Institute of Law of International Institutions. In her talk, she will focus on the dawn of inalienable and equal rights of the human family. Dr. Chiara Berneri is a lecturer in law at the Open University, United Kingdom. Her research focuses on 3 movement of workers, EU citizenships, family reunification, and broader EU immigration-related uses, private sponsorships for refugees, and European human rights. Her monograph on the protection of refugees and private sponsorships is due to come out in August 2022. She will talk about the origins of the Convention for the Protection of Human Rights and Fundamental Freedoms. And Dr. Natalia Ochoa is doctor in law, lecturer in public international law and European law. She's author of many articles and books on human rights and bioethics. She will talk about the human dignity in the case law of the European Court of Human Rights. Dr. Marinella, you have the floor.
Thank you very much, Professor I share my screen. Okay. So starting with the expression at the dawn of inalienable and equal rights of the human family, my contribution will focus on a turning point in the history of human rights, which was the conclusion of the Universal Declaration of Human Rights. It is a document that summarizes all previous demands of the human rights movement, if we consider the fact that the term inalienable and equal rights brings to mind the Declaration of 18th century and the Liberal Revolution for the proclamation of civil freedoms. However, the Universal Declaration of Human Rights did not define for the first time the relationship within a state between the individual and the governing authority, but a set of rights that a human being has as a member of the entire human family, without limitation of time and space. Before proceeding, we need to take a step back in time. The first time the international community understood the need to reaffirm the faith in fundamental human rights was during the negotiation process for the conclusion of the United Nations Charter. The Second World War had shocked to the core the minds and hearts of people, and it put in everyone the desire that never again should such a scandal be repeated. It is remarkable to note, as some scholars have, that some state representatives of that time did their best to rebuild and make the world a better place, when the brutality of the two world wars could have made people abandon hopes for the destiny of humanity. For this reason, some references to the human rights protection needed to be included in the UN founding treaty. Notwithstanding this, there were different points of view among the member states, and some reservations were made on how such a clause should be inserted. Some delegation, in particular the Western countries, thought that the human rights protection should be confined to a political and programmatic level. Others, for instance, the Latin America countries, thought that the agreement should regard a legal obligation on the topic. This dispute was connected to the fact that the inclusion of a human rights clause would have forced the states to give up part of their sovereignty and hand over it to an international authority that would judge the treatment of their citizens and the guarantee of their primary needs and fundamental rights. That is why during the San Francisco conference for the adoption of the UN Charter, it was decided to mention the protection of human rights in 7 points of the treaty, neither specifying their meaning or providing a catalog with the exact rights safeguarded by the organization. The need to protect human rights was recognized in the Charter only as a non-binding principle, namely as an auxiliary aim to the organization primary objective, that being the preservation of international peace and security. Similarly, in order to prevent the excessive interference of the organization within the internal affairs of the states, a clause to defend their sovereignty was included in the text, Article 2, Paragraph 7, according to which the United Nations has no authority to intervene in the matters of domestic jurisdiction of any state. What was unreachable in the San Francisco conference was obtained later. In fact, in 1946, the UN Economic and Social Council was instructed under Article 68 of the Charter to create the Commission on Human Rights in a nuclear form. It comprised of 9 members under the chairmanship of Eleanor Roosevelt, with the purpose of drawing up an international catalog of human rights, which had not been included in the UN Charter. However, this had to be accepted by all the UN member states that were very different one from the other, even if they were just over 50 and not 193 as today. 6 member nations were within the emerging socialist bloc. In 11, the Islamic culture was strong. 4 countries had a large Buddhist population, and in 37, there were Judeo-Christian traditions and Enlightenment thought. Therefore, it was very difficult to find a common denominator. Notwithstanding, thanks to the invaluable work of Mrs. Roosevelt, who was appointed as president, the Lebanon's rapporteur Chaz Malik, and some state delegates like the French René Cassin, known as one of the most prominent fathers of the declaration, The text was concluded in only 2 years and adopted by the UN General Assembly on 10 December 1948. As far as the content is concerned, the preamble and the proclamation, as well as Article 1 and 2 of the 30-article declaration, belong to what is called the general part, because these sections set forth premises, purposes, and principles that guide the interpretation of the rights in the Article 3 to 27. They are based on ideas like the recognition of human dignity, the unity of human family, the aspiration for peace on earth, and on some principles like dignity, freedom, equality, and fraternity. Then, the structure was defined by Cassaigne as a portico, sustained by 4 pillars: the rights of person, the rights of the individual in their relations with others and within the civil society. The third group is made up of political rights. The fourth category was very new because it elevated to fundamental rights status several new economic, social, and cultural rights. And a fifth section, which Cassaigne called the temple pediment, built on the aforementioned 4 pillars, is composed of 3 concluding articles that establish a number of connections between the individual and the society, based on the duties, limits, and general order for respecting the principles and purposes of the UN Charter. As mentioned before, the declaration was the result of a difficult and a demanding task for from various points of view. From a political viewpoint, it was an agreement on common practical ideas. In fact, contemporary with the UN Nuclear Commission, UNESCO appointed a committee on the theoretical basis of human rights, known as the Philosopher Committee, with the task to examine the feasibility of a universal declaration desired by the United Nations. This research on the foundations of human rights was very important and was used in concluding that the main points of the draft declaration there were in many cultural and religious traditions. However, the UNESCO group concluded its work ascertaining that, yes, it was possible to reach an agreement between the various cultures regarding some rights that may be seen as implicit in man's nature as an individual and as a member of society, but they couldn't regard the theoretic foundations of human rights. The memory of Maritain, who was at that time ambassador and the head of French delegation of UNESCO, is well known when he exclaimed, "Yes, we agree about the rights, but on condition no one asks us why." René Cassin will later define the thought of Maritain, who had a great role in the UNESCO team, as practical idealism, because the goal was not to reach an agreement based on speculative ideas and theories, but instead on common practical ideas to guide action and to be accepted by people from different social and political background. From a political point of view, it was a difficult compromise before the escalation of the Cold War. There was, above all, a group of Western countries who took the leadership from the beginning. The United States of America, France, and the United Kingdom, who suggested the extension of the solemn principle of the Independence Declaration of the 18th century to a world level, namely based on civil and political rights, and with an individualistic connotation. A second group was formed by the Latin America countries. In some cases, they were even more brave than the Western countries, because they believed in a binding text. In opposition of these 2 groups, there were the European socialist countries who wanted the inclusion of a series of economic and social rights in the text, and at the moment of the signing of the document, abstained because of the closeness to the blueprint of the Western liberal democracies. The Asiatic countries had little influence apart from the Islamic countries led by Saudi Arabia and Pakistan, who expressed reservations on the matter concerning religion and family life. So, although it was possible to identify these 4 alignments, the major confrontation was between the West and East. In particular, during the final stage of discussions, when the General Assembly began its deliberation on the declaration in 1948, the international scene was extremely tense. Relations were worsening between the Soviet Union and the West. So finding a compromise between different viewpoints was very difficult, and some scholars considered this stage at the starting point of the Cold War. From a juridical point of view, it was a non-binding document. The concern related to the legal nature of the document was the first major point of discussion and debate within the Nuclear Commission. There were in fact some states that pushed for a binding international treaty for the contracting and ratifying state parties, but there were other delegations in favor of a non-mandatory declaration. The main consequence of the dispute was the commitment request to states. In the case of a mandatory treaty, they would have to implement the text in their internal legal systems, and they would be accountable for the compliance of its provisions. In case of a non-binding document, there wouldn't be such an obligation. At the end, the adoption of the Universal Declaration took the form of a non-binding resolution because states were not yet ready for the heavy commitment deriving from a mandatory text. At that time, a policy statement was considered enough. So nevertheless, most of the doctrine takes the view today that whatever the intent of the governments who voted the declaration, the rights agreed in the document now have acquired the status of customary international law, or should be considered as part of the general principle of law recognized by civilized nations, mentioned in Article 38 of the Statute of International Court of Justice. So they have become a source of international law. Others believe that nowadays the declaration has binding effects because it would constitute a specification of the articles of the UN Charter on Human Rights, and it would therefore be an authoritative interpretation of the UN Charter in this matter. So in any case, today, the constitutional value of the declaration is undeniable. Therefore, the declaration is recognized today as the founding pillar of the so-called International Bill of Human Rights. It is composed by the declaration itself and the two international treaties, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, which are intended to define specific rights and their limitation and provide means of implementation. So what are the lessons learned from such a document? Surely the ability to find a compromise, a convergence of wills, a unity in diversity visions of fundamental rights. That was the idea of Maritain related to the existence of a natural law governing everything and his proposal of practical idealism to overcome the disagreements. The Nuclear Commission rapporteur, Chas Malik, defined the Universal Declaration as a composite synthesis of all the outlooks and of much Oriental and Latin American wisdom. Such a synthesis was never occurred before in history. Another merit was its universal application. The declaration, in fact, does not only address members of the UN, but all states in the worldwide community, actually to all the individuals, including stateless persons. This is the reason why, on a French proposal in the Nuclear Commission, the declaration changes its title from international to universal. Thanks to this, the national societies strove to gradually come out from the period when the domain and power represented the benchmark for judging the importance of a state, to favor instead the rise of individuals as the main beneficiaries of international law of human rights. Thank you very much.
Thank you, Marinela. Thank you very much for remember the roots and the principles of the Universal Declaration of Human Rights, because it's for us the beginning of a study on human rights and knowing this consensus that we want to remember, because we think that we need it to put in relation human rights in the past, in the present, and in the future. So the next speaker is Chiara, and she is going to move to the European perspective, because we saw now the universal perspective, and now we move to the European perspective. Chiara, you have the floor.
Thank you, Esther. Just, I'm gonna share my screen. Can you see it?
Yes.
Perfect. Okay, thank you very much. Just very quickly before starting, I just wanted to thank you, Esther, so Professor Salamanca Aguado, for her introduction and for her help with these seminars. And equally, I would like to thank Professor Antonio Maria Baggio for hosting us on this platform and supporting us from the very beginning, and Professor Adriana Cosseddo for her guidance and inspiration from the very early phase of the creation of these seminars. So, as Esther just said, I'm going to focus on the European perspective, and in particular on the origins of the Convention for the Protection of Human Rights and Fundamental Freedoms, most commonly known as the European Convention on Human Rights. And what has interested me, and that's going to be the focus of this presentation, is on one side the historical origins, so how this convention came about. It didn't come out of nowhere. So I wanted to see how that happened. And also, I would like to briefly highlight in this presentation the political compromise that led towards the final drafting and agreement of the convention. So I'm not gonna focus on the specifics, not gonna look at all the rights, etc. This is gonna be probably the object of other seminars. These are the two key points I would like to look at. So in this first slide, I wanted to start with a beautiful picture of where the convention was signed. So the convention was signed on the 4th of November, 1950 in Rome, in Palazzo Barberini. And this is the Salone of Pietro da Cortona. And it's called like this because the ceiling has been painted by him. And I was really struck by the beauty of the place in which this convention was signed. And it was originally signed by 12 states, and now we have 47. So clearly, just looking at the numbers, it was a success, right? And the other thing that really struck me, and I wonder if there was a subliminal sort of message from the drafters of the convention and the signatories, is that this beautiful ceiling that was painted by Pietro da Cortona in the 17th century is dedicated to divine providence. Actually, the painting is called the Allegory of Divine Providence. And somehow I was wondering whether this was like, there was a belief by the first signatories that this convention was actually the fruit of divine providence, given that the negotiations were so difficult. And up until the end, it was not certain whether this convention would have actually become a real treaty, okay? But that's a bit of speculation on my side. Okay, so let's have a look at how it all began. So we live today in what Louis Henking has defined as the age of rights. But this was not always so. I mean, when we talk about human rights, this is a quite recent concept. It's a concept that was born towards the end of the Second World War. And before that, this expression was not in common use. You may say, well, obviously, people talked about rights. There was the Declaration 2 years before, and even earlier there was a big philosophical debate on natural rights, and that's true, and that's a debate that has all the roots, starting from ancient Greek philosophers, going through the Christian tradition with Thomas Aquinas, and then scholars like Francisco da Vitoria, Hugo Grotius, and during the Enlightenment we have Locke, Hume, Bentham, who was a detractor of the natural rights theory. So in a way, the debate on rights was there. But I think that the shift towards this new concept of human rights really occurred towards the end of the Second World War. And we're going to have a look at in a second at the reasons behind. So this slide says that basically the drafting of codes and the development of a literature on human rights, as I said, became influential in the later years of the Second World War, and in particular, at the very beginning, thanks to the work of Professor Urs Luterpacht. So he was very famous, still very famous to this age. He was a professor at Cambridge University. He was a judge in the International Court of Justice, and is considered one of the fathers of international law as we understand it today, and not just that, one of the fathers of the human rights discourse. And he wrote this book, An International Bill of the Rights of Man, which is the first book on human rights, okay? And in this book, he gave a systematic description of human rights. He actually came up with his own fully grown bill on human rights, with a series of rights listed, and also with explanations on each right that he listed there. And also another very important aspect of his work was that he didn't simply come up with a list of rights, but for him, what was really important was that these rights could be enforced by the individuals against the state, okay? And this is something important because Marilena before talked about the Universal Declaration, saying that eventually it was agreed as being as a non-binding document. But here we see that there is a push towards human rights being actually enforceable, to create a liability on the state. Okay. So, a question that came to me when I was doing this research for this presentation, I was wondering, well, why did the UK and all the other European countries decide to draft and sign this convention? And there's a very nice quote that I found in this book that I highly recommend, because it gives a very interesting outline of the situation before that led towards the signing of the convention. And in this quote, basically, Professor Simpson says, well, why would a state sign a treaty, a convention that limits its own power? So the very existence of this covenant is the belief that the governments are the major delinquents. And that's true, right? Because it's basically sort of a limitation auto-limitation that the state gives to its own sovereignty. And so the state is basically saying, okay, if I make a mistake, I will be liable. So why would a state give up this sovereignty? So let's have a look. Well, and this is something that I didn't know, but reading, I kind of realized that the interest in human rights at the very beginning began as a matter of foreign relations, right? It was not a major concern at a level of domestic governments. So basically, the states were witnessed the atrocities of the Second World War and really wanted to do something to avoid that for the future. But at the very beginning, that doing something was relegated to the international diplomatic relations rather than taking the things into their domestic jurisdictions. And it is proved by some few examples that I found in my readings, but apparently politicians, domestic politicians, and even scholars like lawyers, etc., were not familiar with the term at all. In the years, the phrase human rights in the years following the end of the Second World War. That was at the beginning a matter of foreign relation that didn't have much to do with the domestic governments. However, things started to change, and not so slowly, because as the atrocities perpetrated by the Nazi regime became more and more apparent and common knowledge to the public, then the idea of a creation of a new order at the end of the Second World War started to become really, really key and really, really important. And how do you create a new order? How do you put back the individual against the power of the state? Well, the idea that you can do that by introducing human rights that are enforceable for the individual against the state started to sink in very, very quickly. And eventually, the human right concept became a factor that even politicians domestically could not ignore anymore. So they had to deal with it, and they had to deal with it seriously because there was a demand. So let's have a look at how the human rights idea then concretely took shape in Europe. And so this is interesting because we are at the end of the war, and this is a process that somehow involved both the birth of the Convention, the Council of Europe, and in parallel also the birth of the European Union. The beginning was somehow all together, and then the two jurisdictions and the two systems took different paths, but the origins were the same. So there was this idea of federalism, the idea that Europe could come out of this situation just if it was united. And how could Europe become more and more united? Well, it can become united when freedoms are more and more protected. And the first crystallization of this idea of protecting freedoms, the idea of protecting human rights, came from the Brussels Treaty of 1948. This was a treaty that was not particularly successful, and eventually it terminated in 2010. But you can see in the preambles that the key aims was to protect the morals and the values of Western civilization. So in a very sort of convoluted, implicit way, the commitment to human rights was crystallized there. But that was not the end, because obviously there were more and more pushes towards more and more integration and more protection. And that eventually led in the same year to the Congress at The Hague. Now, this is a very, very important historical moment, because this is where the European Charter of Human Rights, the European Convention, became the center of the stage. So I have a couple of quotes very briefly that I want to mention, but I think they are quite emblematic of the importance that the importance that the countries that participated to the Congress at The Hague gave to this idea of having a charter that recognized human rights for Europe. So we have the opening speech of Winston Churchill, in which he said, in the center of our movement stands the idea of a charter of human rights, guarded by freedom and sustained by law. And then we have the speech of Pierre-Henri Tittingen, who was the former French prime minister and a partisan who fought against the Nazi in France. And he said very passionately, democracies do not become Nazi countries in one day. Evil progresses cunningly. One by one, freedoms are suppressed in one sphere or the other. And then, when everything is in order, a Führer is installed. It is necessary to intervene before it is too late. A conscience must exist somewhere which will sound the alarm to the minds before it is too late. So this conscience that sounds the alarm was the charter, okay? So this was the aim of the Congress, and another aim that the Congress had was the creation of an assembly, parliamentary assembly originally, that would actually draft this charter. And this assembly, this body that eventually was given the task to draft the charter, was the Council of Europe. So the Council of Europe came into existence in May 1949 with the Treaty of London, and at Article 3 of the statute of the Council of Europe, it's clearly highlighted how the importance of the enjoyment by all the people within the jurisdiction of human rights and fundamental freedoms. Quickly, I would like to say that the Council of Europe itself, and that this leads to the second point I wanted to highlight in this presentation, the Council of Europe itself, the settlement and the structure of the Council of Europe was the fruit of political compromise, because we had two competing views. We had the French, who wanted within the Council of Europe the preeminence of a parliamentary assembly that would debate freely about any issue. And then we had the UK view, who wanted instead a committee of ministers that would debate things in closed door. And eventually the Council of Europe ended up having both bodies, so both a parliamentary assembly and a committee of ministers. So again, the Council of Europe itself is the fruit of compromise. And then the convention. The Council of Europe, straight after it was founded in May 1949, and in August the negotiations within the Council of Europe for negotiation on the European Convention started to take place. Now, the negotiations were quite the negotiation themselves were done over a reasonably short period of time. So between August 1949 and September 1950. So they were quite quick, but they were very difficult. Why were they difficult? So there were a series of proposals that were debated, and probably the proposals on a charter to be decided and agreed and signed. And one of the most popular proposals came from the European movement. So the European movement was the movement that promoted more federalism and more unity within Europe. And so what were the key aims of the proposal of the European movement? I listed them in the slides. So the first one was to maintain intact the human rights and fundamental freedom assured by the constitutions, laws, and administrative laws actually existing in every state. So this shows the protective and defensive nature of the convention. So the convention itself was never thought as something to be something new. So there was this recognition by the states that freedoms were already somehow protected within their jurisdiction. Then, unfortunately, the war happened, Nazism happened, and that stopped the protection of rights. But now that things were over, it was important for these countries to have these freedoms restored and protected by the Charter itself. Then the European movement wanted to establish a Court of Human Rights. So going back to what I said before, this idea of enforcement, effective enforcement of rights. And then a very controversial point, the European movement did not want to define the rights of the convention in a very precise manner. Why is that? Because there was no time. Time was precious. There was another threat at that time, which was the threat of communism. Okay, so it was important to agree on a list of basic rights that the court would protect, and the court will have the role to put the flesh on the bones of these rights that are just set up in broad principles. This was the proposal of the European movement. And this proposal was fought against by the UK. The UK in particular found this proposal problematic, found the proposal problematic because of the lack of definition of rights. And they thought that this would give too much power to the court. And then they found it problematic because of the role of the court and the right of individual petition, because the idea that the individual could go to the court and claim rights, they thought that this was a problem for the sovereignty of the member states. And then there was an extra point about the colonies, because the proposal of the European movement wanted the convention to be applied also to the colonies. And the UK, and to be fair, also other states that at the time had colonies, did not agree or fully agree on that point. So eventually, what did we have? We came up with a compromise. So, and there were strong reasons for compromise, because the reason for compromise was the fear that of the disastrous consequences if this first attempt of European collaboration failed. So the final result is a compromise between the European movement version and British version. So what did we get? We got a commission and a court, rather than just a court, and a tempered right of individual petition. So initially, we had a commission that could select whether and choose whether the case should go to the court or whether the case could be maybe just dismissed or solved, the situation, that the problem could be solved at the commission level. And so this was acceptable by the UK because the power of the court was somehow tempered. We have rights that are not fully defined. And now I'm running out of time, so I don't have time to give examples, but some rights are included in very broad terms, but the UK accepted that, compromised on that. We have a colonial clause, so the European movement compromised on that. So the colonial clause that is still there. So it's up to the state to decide whether the convention can be extended to the colonies or not. And then the states reached compromise on whether certain rights should be introduced or not. So I found two very striking examples that I want to mention. The first one is about Article 8, so the right of family and private family life, home and correspondence. And the European movement really wanted to put under the protection of this article, the sanctity of the home, which was really important for continental Europe because they experienced the Nazi regimes, and they experienced concretely people getting to people's house and taking people and taking their belongings. So they really wanted that in the text, and the UK and other states agreed on that. And then there was a compromise on the introduction of Article 3. So the protection against torture and inhuman and degrading treatment. Some didn't want this article to be introduced because they thought, well, it's actually already covered by Article 2, right to life. But some others really wanted the article to be expressly mentioned in the convention. And the second option eventually was adopted, and we do have Article 3 in the convention. Now, finally, I don't have conclusions, but I have questions, which I hope we can discuss at the end together. So what as I said, I was really struck about this idea of political compromise. And it looks like the conventions was the fruit of political compromise. So could or should we today work towards a new political compromise now that the challenges are different, are not the same as the 1950 ones? And the other point is that it looks like these days the content and interpretation of the meaning of a right is more and more delegated to the court. If so, is there still room for political compromise, or should there be room for political compromise? Should the court take the lead on this, or should we have political compromise? And now, finally, what would be the best way to achieve a workable compromise? So these are my questions, and I hope we can discuss all this together at the end. Thank you.
Thank you very much, Chiara, for this interesting presentation. You bring us back to the political compromise in the origin of the convention, and you also mentioned the important role of the court. So I'm going to introduce the new one, a later speaker, who is going to talk about the notion of human dignity, that is the foundation of all human rights, and how the court has interpreted this notion. Natalia, you have the floor.
Hello, can you hear me?
Yes.
Can you see me?
Yes, we can.
Okay, thank you. So, good afternoon, everyone. And I would like to begin by very quickly thanking the Sophia University Institute for having me in this seminar. And I also would like to thank Antonio Vallo for hosting us, Esther Salamanca for her coordination work, and the speakers for their very interesting presentation. So my presentation links very well to Chiara's presentation because I would like to speak today about human dignity in the case law of the European Court of Human Rights. So Dr. Chiara Berneri has talked about the convention. And here I would like to focus on the how the European Convention of the European Court of Human Rights has had the opportunity to develop the contents, the rights proclaimed in the European Convention, and how, in my opinion, has distorted some of them. I think I'm going to be a bit critical. So I will begin by posing a challenging question. What is human dignity? Well, it is a very important question. We are all aware of having human dignity. We know that all human beings, just because they are human beings, have human dignity. However, there is no universally accepted definition of human dignity. Nevertheless, all international human rights legal documents are based on the recognition of human dignity. For instance, Article 1 of the United Nations Universal Declaration of Human Rights says that all human beings are born free and equal in dignity and rights. And then the International Covenant on Civil and Political Rights affirms that rights derive from the inherent dignity of the human person. So here we have the first problem. While the Universal Declaration speaks of human being, the Covenant speaks of human persons. Are they not the same thing? Well, apparently not. All documents, for instance, all legal documents on human rights recognize the right to life. But this right is not recognized for the unborn. Officially, there is no international recognized right to abortion. But no international body condemns this practice. And why does the unborn have no right to life? Because there is a legal distinction according to which only individuals, that is persons, are rights holders. So human beings are members of the human species, but they are not persons. Therefore, only persons have the right to life. And moreover, some philosophers, such as Peter Singer here on the screen, affirm that the key element for someone to be considered a person and a holder of rights is to have self-awareness and be capable of feeling pleasure or suffering. So the unborn children and newborns have no self-awareness, and therefore they are not persons. For Peter Singer, there is no distinction between human beings and animals. Certain animals with brains and the capacity to feel are superior to certain human beings, such as human embryos. So for him, animals have animal dignity and animal rights. For some thinkers, even the nature has rights. There is some declaration about the rights of the nature. So as you can see, the notion of human dignity is being diluted. There are human beings that are not persons and do not have rights, but there are some animals that should have dignity and rights. It sounds a bit crazy, but that's the way it is. So now, having exposed some of the problems with the notion of human dignity, I would like to turn to the European Convention of Human Rights. So Chiara has talked us about the European Convention in her very interesting presentation, but it's quite striking that neither the European Convention nor its additional protocols mention human dignity, but the European Court on Human Rights, through its case law, has affirmed that states have the duty to respect and protect dignity. And it has affirmed this in many cases. So in practice, the court has said that the very essence of the convention is respect for human dignity and freedom. And the court has used this formula in many rulings in relating human dignity to almost all the rights recognized in the convention, such as the right to life, the provision of torture and mistreatment, the provision of slavery, servitude, the rights to liberty, security, freedom of expression, the provision of discriminations, and many others. So I have extensively studied the European Court on Human Rights case law, and I think there are many very positive aspects. For instance, the court has held that human dignity implies a duty to guarantee certain living conditions of the people. And as I have said, the court has linked human dignity to virtually every human right. But there are also some debatable aspects. And I'm going to very quickly focus on three aspects: the protection of the unborn, the fate of frozen embryos, and the so-called right to die with dignity. So, as I have said, the unborn does not have the right to life because only persons have the right to life. And when dealing with abortion, the court has put two rights in the balance. In one side, the right to life, is stated in Article 2 of the Convention, and on the other side, the right to privacy, is stated in Article 8. And I would like to focus on this right to privacy, or as the Convention says, the right to respect of private life. Traditionally, this right implies the recognition of a sphere, of an area in which the state may not interfere. It's a private area, such as your more intimate area. But in the European Court on Human Rights case law, this right has turned into the right to personal autonomy or right to privacy, which is not the same. The court has understood this notion of private life in a very broad sense. For the court, the notion of private life is a broad notion that encompasses, among other issues, aspects relating to the physical and social identity of an individual, In particular, the right to personal autonomy, the right to personal development, and the right to establish and maintain relationships with other human beings and the outside world. It even includes the right to respect decisions to be or not to be a parent, and also the right to respect for the decision to be a parent in the genetic sense of the term. And this interpretation has had a very profound impact on important issues affecting the notion of the content of dignity, the value of life, and the very ontological understanding of human being. So let me look at these issues. So, concerning the protection of the unborn, in one case, Vaux against France, that concerned an involuntary termination of pregnancy. In this case, it was a pregnant woman called Vaux. By mistake, she underwent a medical test that resulted in the death of the fetus. So, before the when the case was brought to the European Court, the court says that there was no European consensus on the nature and status of the embryo and fetus. At most, there could be consensus among states as to whether embryos and fetuses belong to the human race. But the potentiality of this being and its capacity to become a person required protection in the name of human dignity, without making it a person with a right to life. But the court never determined what kind of protection the unborn deserved. This question remains open. And even worse, from the beginning of this century, several cases were filed against Poland and Ireland. As you know, the legislation on abortion in these two countries were quite restrictive. So the lawsuits sought to make the national laws more permissive. So in one case against Poland, the first of these series of cases, we can see that the European Court stopped examining the question of abortion on the basis of Article 2 of the Convention and began to examine it only on the basis on the right to privacy of the woman. So for the court, it was enough that in the respondent state, there was an adequate procedural framework to assess whether abortion was lawful in the specific case, no more than that. So from this case, the court has not speak again about the protection that should deserve the unborn. So, and this approach has influenced the case law on in vitro fertilized embryos and also on euthanasia. Starting by IVF techniques and the fate of frozen embryos, there have been several cases concerning the legal restrictions existing in certain countries for several IVF modalities. So in these cases, the court only took into account the parents' rights to privacy, but did not consider at all the dignity and the right to life of the embryos. Let me put an example. In the Evans case against the United Kingdom, Mrs. Evans wanted to have some frozen embryos implanted in order to start a pregnancy, but her former partner, Jay, wanted them destroyed. So the Grand Chamber of the court said again that the embryos had no right to life. And since Miss Evans and Jay disagreed as to the fate of the embryos, the court said that they should be destroyed in accordance with British law. So the court gave more weight to Jay's autonomy of will than to the right to life of the embryos or the applicant's desire to become a mother. The last example I would like to share with you is the so-called right to die with dignity. Because this case law on the autonomy of will, on privacy, has also influenced the court's case law on the end of life, such as euthanasia, assisted suicide, and the withdrawal of life support for patients considered incurable. Here we have a photo of Miss Diane Pretty. She had an incurable disease in an advanced state. She wanted her husband, here on the picture as well, to help her die. She wanted to avoid suffering and the indignity of the death that awaited her. So her situation was really, really sad. And the case was brought before the European Court, and the court understood that Article 2 could not be interpreted without a distortion of language as conferring a right to die. So the Convention on Human Rights does not encompass a right to die. However, the court admitted that without in any way denying the principle of the sanctity of life protected by the Convention, the notion of quality of life acquires meaning. So, although the court found no violation of Article 8, it related Article 8 and human dignity to the quality of life. So the questions that may arise from here is that whether suffering and the lack of prospects for healing would deprive human life of meaning, and if there are lives that are not worth living. And in another case, Haas versus Switzerland, the court said that one of the aspects of the right to privacy is the right of the individual to decide how and when to end his life. Well, and let me now turn to other kind of cases. Here we have a photo of Vincent Lambert and also of Charlie Gard. You probably know, you probably have heard about those cases. Vincent Lambert was a patient in a state somewhere between vegetative and minimally conscious. He was responsive to stimuli, he needed care, but he was not terminally ill. And his parents wanted to take care of him, but her wife preferred him to die. And concerning Charlie Gard, maybe you remember it happened 4 years ago. So he was a baby with a rare disease for which there was no treatment, and he was not terminally ill. His parents wanted to try experimental treatments, and hospitals in several countries, such as the Vatican and the United States, offered to treat him. But in both cases, the French and the British authorities decided that both Vincent and Charlie's lives were not worth living, and it was better to withdraw life support. So my question here is, do chronically, incurably, or terminally ill persons enjoy human dignity and the right to life? Or does the right to life only apply when some quality of life conditions are met? And just to end, let me share with you some final reflections. In my opinion, the European Court on Human Rights should make a calm and in-depth reflection on the foundation and content of human dignity, the value of life, and the conception of the human being. After all, the purpose of the European Convention is to protect human dignity and the rights deriving from it. Therefore, it is necessary to reflect on what human dignity is, seeking to grant the greatest protection to every human being, especially the most vulnerable. And thank you.
Thank you very much, Natalia, for so this complex uses about right to life and how the European Court is trying to define and protect this human dignity. Okay, we are going now to open camera of the panelist. Marilena had a problem with a domestic problem when we are doing these virtual webinars. So she's not here now, but she promised to come back as soon as possible. And now I am going to go to the chat because I have some questions. Maybe you can also read it. There is two questions from Valeria. She said, being soft law, does the Universal Declaration of Human Rights have no value? And also, what is the relationship between the universalism of the Declaration and the regionalization of human rights in the Council of Europe? Well, this is two very broad questions. Well, it's not, Marinella is not here, but I think some of the other panelists can answer if you want. If not, I can also answer something later. You, Chiara or Natalia, do you want to say something about that?
Yes, I can. Sorry, I'm just trying to get to the question as well because I can see just because I didn't get the second part of the question. I think, well, for the first one, I can say that it's not, well, going back to the presentation of Marilena, I think it was originally thought as not being a binding sort of piece of legislation, but eventually it kind of, and it is considered to be part of customary international law. So it kind of achieved that sort of perhaps legal binding status somehow with time and with practice. And sorry, I missed the second part of the question.
Relationship between the universalism of the Declaration and the regionalization of the human rights in the Council of Europe. Is the problem of universalism and regional systems of human rights. I would like to say just one thing.
Yeah.
When we prepared this seminar, we were aware that there are a lot of people from other parts of the world, not from Europe. We have started from Europe, but we promise to go to other regional areas, Africa, America, Asia, to try to understand how human rights has been developed and interpreted in this other regional. So today we focus on Europe, but we promise to go to other parts of the world. Chiara.
Yeah, I think there is certainly a relationship between the Universal Declaration and then the regionalization within Europe of the protection of rights. The thing that to me is striking is to see how basically the European Convention of Human Rights took a strong inspiration and influence from the Universal Declaration, and then did this extra added value, which is the enforcement, the actual enforcement of these rights in front of the court, because they introduced at the beginning a commission and a court. But certainly there is a relationship, and in my presentation I mentioned the work of Professor Lauterpacht that highly influenced both the Universal Declaration and the drafting of the European Convention of Human Rights. So it's all very much connected, and the time frame, if you think about it, is very close. So Universal Declaration 1948, 1950 European Convention.
Natalia, did you want to add something?
Yeah, thank you, Esther. I would just like to elaborate on something that Professor Berneri has said. There is certainly a trend to regionalization of human rights, not only in the Council of Europe, but also in the Americas and in Africa. And it's quite logical because although human rights are universal, but at the same time, there are different traditions in every country, or sorry, in every continent. So it's quite logical that there are specific documents for, or a specific human rights protection system for every continent. For instance, in Africa, they give a lot of importance to the community, so and the people. So in Africa, they have the Charter of not only of human rights, but also the people's right. So this is fine as long as you do not contradict, which is more essential, which cannot be derogated. So, yeah.
Thank you very much. Very interesting point, that because sometimes there is a criticism against universalism, but I think we can talk in other seminar about that, but it's possible to compatibilize the universalism at the same time the regionalism. So this is an interesting topic. There is another question for Chiara. Speaking of UK's view on the European Convention or Court of Human Rights as problematic, do you foresee any problem for European citizens in the UK's proposal of amending the
Human Rights Act?
Bill of Rights conflicts with the European Court of Human Rights? Do you know something about that? Because I don't.
Well, there have been talks about basically, the European Convention of Human Rights was incorporated in the UK by the Human Rights Act of 1998. And after that, there were talks, still ongoing, about amending it and maybe changing it into a national Bill of Rights. So whether there would be consequences if this change went through. It's a difficult question, but very interesting. I think that it will depend on whether the UK would still be part of the European Convention or not, because if the UK decided to change the European, to amend the Human Rights Act and change it somehow into another act, but still being part of the convention, then I suppose there would be still that sort of overarching jurisdiction and the check of the European Court of Human Rights. But if the UK decided to withdraw completely from the European Convention and start a protection of human rights of his own, perhaps there wouldn't be that overarching power that checks. Whether that is a good thing or a bad thing, I don't know. It's disputable because it depends. I mean, I think that the UK, even before the introduction of the Human Rights Act, certainly protected freedoms, civil liberties, and some human rights at common law level. I think the convention gave added more, like, for example, the right to privacy that before didn't exist at common law and now is very, very important. So I would argue that the UK should still stay within the convention, but then whether it would be possible to change the Human Rights Act, why not, if there is consensus, political consensus, I think.
Thank you. There is a question, comes from YouTube. Congratulations to the organizers and speakers. And okay, this is the question. Many constitutions, for example, the Spanish or the Italian, in addition to rights, contemplate different duties, the duty to work, the duty to contribute to the expenses of the state, etc. The main human rights declarations, however, express recognition of duties. What do you think may be due to the difference in this meaning between national constitutions and international treaties? Well, I don't know if you want to answer, but I will say something important. I mean, the difference between a treaty and a constitution, because a constitution is a supreme norm in a state, which is a centralized politic power. And we have in the international community, treaties are not the same as a constitution if we compare. We have the Charter of the United Nations, which has constitutional character, but treaties are governed by very different law. So to me, duties has a relation with solidarity. That this is a principle that is very institutionalized inside the state, but not in the international system. So this is a topic I would like to work on in a seminar, because this aspect of solidarity and duties, because it's true that the Universal Declaration has the duties to the community. It was clear that the human being do not live alone, live in relation with community, with a family, community, and other groups, including the humanity. So this approach is solidarity, and it has not been yet developed in international human rights law. This is, to me, the answer, but maybe you can say other thing.
I can just add something very quickly to that, and I think your explanation is the one that makes very much sense in terms of distinction between the two subjects. I think also, from my point of view, thinking about the European Convention, I think there was a focus on rights also for historical reasons, because there was this, the Second World War and the atrocities that happened were very, very fresh in the people's minds. And so people really wanted to protect the individual against the state, hence all these rights. I think, and I'm not an expert on that, but the African Declaration, actually the African Charter on Human Rights, has stresses instead, not just rights, but also duties. In going back to what you said, Natalia, this idea of solidarity, of group duties, like protecting not just the family, but the group I come from. So, but that's, it was agreed for different historical reasons in 1981, which is another era. So I think there are also historical reasons connected to that.
Something else? No comments?
No.
Well, I think there are no more questions. It's 7:38, so I think we have arrived to the end. I'm very grateful for this seminar, first seminar, because we have been working on this during some months, trying to find the best way of doing this. Is our intention to organize in the future workshops or seminars in presence, maybe in Lo Piano or maybe in other places, but at least we can see each other in this format, virtual format, and to start, because this is the beginning of something. It's not a conclusion. So we will like to start a dialogue on human rights, because there are a lot of challenges and new frontiers, how we have called this cycle of seminars. I don't know if Professor Bayo is here or he is out of the Zoom, if he wants to say something. If not, I would say thank you all the participants also in YouTube, following on YouTube or on Zoom. And I hope to see you again in the future.